Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning, everyone. Welcome to the March session of the Tennessee Court of Criminal Appeals. I'd like to first introduce the panel. Can everyone hear me okay? Yes. Wonderful. To my right is Judge Timothy Easter from Franklin, Tennessee, the Middle Division. To my left is Judge Jeffrey Usman from Joelton, Tennessee. He's on loan to us from the Court of Appeals. And my name is Camille McMullen. I'm the presiding judge of the Tennessee Court of Criminal Appeals, and I am from Memphis, Tennessee, the Western Division. So I'd like to welcome everyone here today. The parties know it's 20 minutes per side. If the appellant would like to preserve rebuttal time, please let us know. We are on the light system, so pay attention to the lights. They will let you know as you run down your time. I will try my best to keep up with your rebuttal time. Again, the lights will let you know as you run down if I lose track of your rebuttal time. And also, Madam Clerk, I think, is also trying to keep track of your time. With that said, Madam Clerk, do we have any preliminary matters?
No, Your Honor.
Let's call the first case.
State of Tennessee versus Daniel J. Dreaden.
Mr. McNally, it's good to see you.
Thank you, Judge. As already introduced me, I'm Pat McNally, and it's my pleasure to be here on behalf of the appellant, Daniel Dreaden. I would like to reserve 5 minutes for rebuttal. This particular case, in my brief, I identified two potential issues for review on appeal. That was first, whether the trial court abused its discretion excluding cross-examination of the wife, then ex-wife, accuser of Mr. Dreaden of the rape charge, and then second, whether there was insufficient evidence. But given the state's brief, I think really the first two issues on this matter is, one, what is the review? Is it going to be plenary or is it plain error? And then number two, was there a structural constitutional violation when the judge did not allow under Tennessee Rules of Evidence 412 the cross-examination of the accuser that she was engaged in an extramarital affair? That's a mouthful there, and I apologize, but I was trying to make sure I got it out there as to what the nature of the evidence was. As a little background first, this case started with a couple that was married, had 2 children, and the wife was having an affair with her superior or her commanding officer at the National Guard.
Yeah, is that in the record?
Yes, it is.
Who she's having an affair with?
Yes.
Okay.
Well, it's in the record during the pretrial hearing
on
the matter whether to exclude or to not exclude it. And the parties were once in a while kind of still together, kind of still raising the children together, still occasionally sharing the marital bed again and everything. And then 9 months later, the wife goes to law enforcement and says that she has been raped by, as it was in the 2 counts, it was basically lack of consent because she said she had taken Benadryl and had alcohol and did not, it was one of 2 things, either intoxicated to the level where she couldn't consent or she didn't consent because she was asleep.
And I was a little unclear on that.
Yes, sir.
The proof was that she wasn't alleging that she was drugged by the defendant. She's not making that kind of allegation.
Correct. She is not making that allegation. She testified that she voluntarily took those. She did testify, I'll be candid, she did testify that Benadryl knocks her out. Mm-hmm. And there's a lot of cross-examination about how she doesn't remember things after she has taken Benadryl or been drinking. But getting to the point now, the first thing is, what is the standard of review in this case? And we have said that it is actually not plain error, it's plenary review, because under Tennessee Rules of Evidence 103A, by the context of what was brought in this case, it is clear that Mr. Dreaden's trial counsel was bringing a claim of confrontation, of a denial of right to cross-examine the accuser.
Well, let's talk about what
Yes.
was actually raised. This is not a 412 issue, right? It's really not. You
Go
tell
ahead.
me,
No.
because from what I understand, what was actually raised was this was in response to a motion to exclude by the state any testimony regarding an extramarital affair.
Yes,
And so in response, defense counsel filed a motion indicating that this evidence would preclude his right, in addition to other things, to confront his accusers. That's where the whole confrontation right was raised. Is that accurate?
correct. And I really appreciate the fact that the court at least has the impression that this is not a 412 issue. It was analyzed by the trial court as a 412 issue. It was.
Well, let's be clear on what
Okay.
the record is saying here, because the trial court did kind of like a quasi Rule 412, Rule 608B. He was trying to cover what I would think would be every base that could potentially be touched upon based on the filings of the parties. Is that a fair assessment of what the trial court did in this case?
That is correct. And in fact, I made sure I copied exactly what the trial court said. The trial court did eventually fall under Rule 608, that this matter was really under Rule 608. But it,
I agree.
Okay.
Go ahead, Mr.
Yeah.
McNally. I don't want to cut you
No,
off. You're trying to get to your point.
I was going to start with the court has pointed out that this matter started on the state's motion in limine to exclude any reference, question, or allusion of the alleged affair of the victim in accordance with Tennessee Rule 412, 608, 402, and 403. Now, Judge, there was a point where the trial court looked at 412 and even went to the 403 balancing test in there. But eventually, as I pointed out here, the trial court landed on 608 for its analysis of this particular issue. Now, what I wanted to point out though was in the pleadings that trial counsel, or the response that trial counsel filed, it specifically said what the state seeks to, as to into that particular paragraph, because you went paragraph by paragraph, it's to paragraph 2. What the state seeks to do in this instance is utilize the general prohibition of Rule 412 to prevent Ms. Dreaden's credibility from being questioned under Rule 608. Again, we got that kind of
Double speak.
yeah. It's very interesting analysis and very interesting case on that aspect. But then it goes on to say, to allow such, trial counsel wrote, to allow such would violate Mr. Dreaden's 14th Amendment due process right to present a complete defense and would bar Mr. Dreaden's access to utilization of Rule 608 to impeach the credibility of his accuser, simply because his accuser's lies involve sexual conduct with Mr. Van Heusen.
Well, let's back up one step,
Yes, sir.
because the primary issue here is our standard of review. And so I'm looking at Rule 103A as well to determine if from the context of the filings, the trial court could glean from the context whether there was a confrontation clause issue properly raised and properly preserved. So talk to me about what exactly was discussed at the hearing to determine whether the confrontation clause was actually raised.
In the confrontation, during the hearing, trial counsel said that he explained that he did not intend to raise specific incidents of sexual conduct or sexual activity, but instead he wanted to show that they were involved in a relationship, an extramarital relationship, in order to show motive. And remember, impeachment involves several things. It can be prior inconsistent statement, it can be biased, and it can be motive to fabricate. Much like the third case I'm going to be on here today, one of the things the court has to look to is for the truthfulness of whether a forensic interview comes in was there a motive to fabricate? And here he spoke repeatedly about he's bringing it in to show her motive to fabricate to gain an advantage in the divorce.
I guess my confusion here, Mr. McNally, is that what was defense counsel seeking to cross-examine the victim on the question of the extramarital affair, or was defense counsel seeking to admit the judicial determination of the Chancery Court, which was a little confusing to me, because on the one hand, what it appears to be going on was an argument being made for the admissibility of the order of the Chancery Court finding the victim's testimony regarding the alleged rape untruthful.
Or regarding.
Or the extramarital affair. Both of those
extramarital
things, the
affair
chance,
and the-
yes.
I'm-
So both of those things, I'm sorry, yes, there were judicial findings of fact made in a separate court. And that is what, in my mind, from the context of where the trial court in the criminal case was grappling with what was defense counsel seeking to do.
Both.
Okay.
Your Honor, it very clearly, in the pleading, the responsive repleading by trial counsel, he talks about wanting to introduce evidence of the judicial finding that the accuser, Ms. Dreaden, had been found by the divorce judge to have been untruthful about the accusations and about the affair. The trial, and I didn't raise that on appeal because I think the trial court properly ruled on that. The court gave it some analysis and discussed it. But I would agree with the trial court that absent something extraordinary, it would not come in. Now, it was interesting that the trial court did say, I might consider that about a judicial finding. It's really pretty interesting. I might consider it as a judicial finding under Rule 608. But
So the way I read the trial court's order, the trial court actually permitted defense counsel to question the victim regarding her truthfulness in a prior judicial proceeding.
the divorce proceeding, yes.
Obviously you couldn't go into the underlying facts of the matter, but the trial court here, I couldn't tell whether he allowed defense counsel. Was it permissible for defense counsel to actually discuss the extramarital affair or not? Because it was almost like he was granting in part and denying in part the state's motion. Does that make sense what I'm saying?
It absolutely does. And I agree. Your Honor, makes sense what you're saying, and I agree with the confusion of the ruling on the transcript from the pretrial hearing, because the court does say that you can ask whether there was a finding of Ms. Dreaden being untruthful under Rule 608, but you cannot question her about the extramarital affair. And that was the other part of this.
So with all of this, when did defense counsel say, well, Your Honor, this would be a violation of my Confrontation Clause rights because you're limiting my right to cross-examine the victim?
I think it's inherent in
It's inherent? Okay.
I'm going under 103A, where it's inherent from the context of the pleading that was filed by counsel as well as the arguments that were there. Clearly, counsel was saying over and over that this is going to deny my client a due process, and it's also going to deny my client an opportunity to cross-examine her about the extramarital affair to show motive to gain an advantage.
Mr. McNally, just so
Yes,
I'm clear on where you're going here, is all of this argument about how this motion was viewed, whether it's 412, 608, 103, just your position that this issue was preserved for plenary review by us? Is that your argument?
Yes, Your Honor, by the context of the pleading filed, the responsive pleading filed by trial counsel and the argument during the course of it, and maybe also by the trial court's ruling, that the context of it, looking in the context of it, as the Bowers case suggests, that in the context of it, it is preserved for plenary review here. And I recognize there's a strong dissent in the Bowers case, but or a firm dissent, I would say. I would also ingratiate myself by saying a well-reasoned dissent.
Thank you.
Oh, you cheapen yourself.
We can all pull our pants up or whatever, But I recognize that. I can't ignore cases that the court has reviewed before and issued dissents and opinions. Frequently, you'll find me embracing the dissents. In this particular case, I kind of embraced the majority's opinion in Bowers, but I think it's correct when applied to this particular case, and I looked at carefully the dissent to make sure that I was staying credible here in presenting that it's plenary review. I hope the court will review it that way. If not, in the brief, I've gone through the 5 criteria for plain error review, and I think it's still strong, even under plain error review, because what's most important here is an understanding that it is a fundamental, non-constitutional, structural, fundamental right to be able to cross-examine your accuser. And then one other thing for the preliminary review. It's very clear that counsel has over and over said due process, and right to present a defense. And I've put in there a number of cases like Chambers versus Mississippi, United States versus Taylor, that says due process includes the right to present a full defense. And a full defense envelopes the right to have an effective cross-examination. This court may say, well, the right to have an opportunity to cross-examine, but still, the right to have a cross-examination. And so I would say the arguments and the context of everything in here, as well as the pleadings, gives us a preliminary review. But what I want to, yes,
Let's
Your
get
Honor.
to the meat of the issue here. You cite Olden.
Yes, I do.
And that really is what you're hanging your hat on, is that fair to say, in this
Correct.
case? All right, so Olden stands for the general proposition, I'm going to give you time,
No,
that a victim's motive to lie, especially in a rape case, is almost always fair game in cross-examination.
Mm-hmm.
All right, in this case, was her motive to lie stemming from her need to protect the extramarital affair? Or is her motive to lie stemming from her need to gain advantage in the divorce?
Does it matter?
Well, it matters in
because-
terms of what you argue.
Well, I will say that what the trial counsel put forth was that her motive to lie was multifaceted. One, it was to gain an advantage in the divorce case, which involved custody of 2 children. Initially in the divorce, Mr. Dreaden had custody of the 2 children. So, as I think any parent would want to try to have custody of their children. But, you know, it was initially to gain an advantage in the divorce proceedings for custody.
Was that argued to the trial court?
Yes.
Okay.
On page 39, Dreaden argued that she had motivation to fabricate the alleged rape to appear as a victim to gain a tactical advantage in the custody and divorce proceedings. That's in the pleading.
Okay.
The responsive pleading.
But not in the hearing?
I would have to double
Okay.
check to be
Okay.
sure, but I know, I'd be surprised if he didn't, if trial counsel didn't mention that at one time or another.
Okay.
But you may be right, but I'd have to go back and look at that hearing to be sure. But I do know it's in the responsive pleadings, and I do know that was the gist of it, the real thrust of it. But getting quickly to, Olden is right on point for us, and I gotta say, I didn't
Counsel,
find.
isn't there a determination though in Olden that the Kentucky Rape Shield law is inapplicable to the case, and doesn't that make it different than the present case?
I would say yes, that there may be, except for the fact that there's still a well, no, I would say it doesn't, because the constitutional right to present a defense and cross-examination of your accuser is fundamental. And statutory rules of evidence have to fall or be subservient to constitutional principles. And that's what we're looking at here, is should this have come in? Because it was critical. I do want to say one thing about this case. At the very end here, this was a close case. It was a bench trial, a one-day bench trial. And interestingly, and kind of as the court held in Plantero, this case held in the balance. The trial court said this, in rendering its decision, the trial court said this was a difficult case. It's not an easy decision based upon the facts in this case. The trial court said, I find the accuser, Ms. Dreaden, to be somewhat lacking in credibility. Had this come in and the trial judge been allowed to add that to the scales, it would have made a difference. And that's where I go even under plain error. This is a substantial right that was denied, and it had a prejudicial effect in the outcome of the case.
Thank you, Mr. McNally. I don't remember, did you reserve time?
I did, but
Okay. That's fine.
I may only have
You
a
have your
minute or two
rebuttal
left,
time.
so
Yeah.
thank you.
Mhm.
Thank you.
State. Mr. Ward. Good to see you.
May it please the court. Good to see you guys as well. Garrett Ward on behalf of the state in the matter of State versus Daniel Dreaden. Your Honors, I agree with Mr. McNally that the first issue that this court needs to resolve is what is the standard of review for this Confrontation Clause claim. And Your Honors, the answer to that question is relatively clear from an examination of the record. This claim was not preserved below, and it is solely reviewable for plain error. And I want to start really my analysis or support my argument with that by pointing directly to the responsive pleadings in this case. So the way this issue sort of came about is the state filed a single motion in limine seeking to limit the defendant's use of two different, I'll say, styles of or types of evidence. One was evidence that spoke directly to sexual encounters between the victim and the defendant. So that's category A. Category B is the evidence that's now the subject of this confrontation claim, and that is this extramarital affair. In response to that single pleading by the state, the defendant filed two separate pleadings on the same day. One of those pleadings dealt specifically with category A, so past encounters between himself and the victim, and the second dealt solely or primarily with category B. There's some other stuff discussed in that pleading because there's some other stuff in the motion, but for purposes of this appeal, the second pleading is about this extramarital affair. In the pleading in which the defendant argues he should be allowed to ask the victim and present evidence about encounters between himself and the victim, the defendant specifically says that preventing me from using this evidence would be a due process problem, would deprive me of my right to present a complete defense, and critically for this issue, the defendant specifically says this will prevent me from being able to effectively confront my accuser. So we understand that the defendant's trial counsel knows how to say that he thinks there's a confrontation problem. Well, we get to the second pleading, the right to present a defense is still there, due process is still there. Counsel specifically doesn't include this the confrontation claim that's now being presented on appeal. So we really have a sort of excellent legal experiment here from Mr. Dreaden's trial counsel of how would he present a confrontation claim if that's what he was intending to do. Well, we can see it in the first pleading. He specifically says it because that's what he was intending to do when he was arguing that he should be allowed to ask the victim about prior encounters between herself and the defendant.
No, that was in response to the Rule 412, okay? That was in response to the state's pleading about I can't remember their terminology, but
Certainly.
he filed two pleadings, the first in response to the 412 rape shield, okay? He wants to put on proof of his relationship with the victim, okay? He's putting the state on notice, hey, I want to talk about prior sexual encounters between myself and the victim. The second one, he gets into whatever the Chancery Court findings of the divorce were.
A little.
I think that's the way I understand how the record unfolds, but
I sort of understand. And I'll sort of agree with the court that this issue was presented a little confusingly.
Yeah.
The state's single motion dealing with both of these categories of evidence cites six or seven rules in regards to both pieces of evidence. I'll agree that insofar as there was a 412 sort of response by the defendant, and there was a 412 hearing that was sealed,
Yeah.
that's not part of this record.
okay.
They're clearly separate things. My point is that when in part of that 412 pleading, another thing Mr. Dreaden's attorney says is this is a confrontation problem, and he doesn't say that here. In regard to,
I guess what I'm really trying to get at, we're obviously talking about gleaning from the context to determine, in the absence of a specific ground,
certainly.
because we're talking about context, what is preserved, okay? And so the state's position is nothing, okay? Was nothing preserved based on the hearing that they had?
Certainly some things were preserved, Your Honor, but what wasn't preserved is the confrontation claim that is being presented now. I'm happy to discuss some of the things that were more in depth discussed at that hearing. But what wasn't discussed at that hearing anywhere is confrontation. There's discussion of I'd say primarily there's discussion of 608.
So implicit in the 608 discussion, can we not glean from that discussion?
Maybe in some cases, Your Honors, it's sort of in the.
I was dissent in Bowers, so
like Mr. McNally, I think the Bowers dissent was well reasoned. But even if we're sort of in the sort of like aura of Bowers here. In Bowers, the context that allowed a majority of this court to say, look, from the context we know there's a confrontation claim. The claim in Bowers was, we're dealing with, I believe it was testimony via Zoom, and the pleading said, I object to like the witness not being in the courtroom or something very close to that. So a majority of this court said in Bowers, well, maybe that's enough. There was some vague allegation of constitutionality in Bowers. There's this specific sort of laser focus on the witness not being in the courtroom. When we contrast that with here, and not to sound like a broken record, I think an important part of the context is that we know Mr. Dreaden's trial counsel knows how to say confrontation when that's what he wants to argue. And when that's what he wants to argue, he just says it. So when he doesn't say that here, I think that's an important part of how we judge the context in this case, is the absence of the clear invocation of confrontation that's present in the other pleading. I think that's an important part of the context here that is wholly absent from Bowers. And I think my second point on context would be, Bowers were really dealing with, these heartland confrontation claims, the witness being in the courtroom and present for in-person cross-examination. Certainly Olden is a claim that rises in the land of confrontation, but it's a little less sort of heartland of confrontation than Bowers is. There's no question here that the victim was going to be in the courtroom, that she was going to be cross-examined, that she was physically present. We're dealing with sort of this odd this small subset of confrontation claims that deals specifically with these motivations to lie in rape cases.
Okay, so even under plain error, why is this not a violation of the defendant's confrontation clause rights? Clearly you had dynamics at play here.
There's certainly dynamics at play in this case, Your Honor. And I think where I'd like to start is differentiating this case from Bowers, or not from Bowers, from Olden, just a little bit, because there are some fairly important differences in sort of who the players are in Olden versus who the players are in this case. In Olden, we have the defendant is accused of raping the victim. The defendant is not someone that the victim has previously been romantically involved with. The victim in Olden was married, had separated from her husband, and was, at the time of the sexual attack, was cohabitating with a boyfriend.
I know the state wants to get and make factual distinctions about Olden, but Olden, the principle in Olden has been applied across the board.
Certainly.
In different situations, scenarios, and the principle is that the victim should be able to be cross-examined on motive to fabricate accusations of rape and or any other thing. Motive is key here.
Certainly, Your Honor, and there wasn't a prohibition from the trial court here on the defendant exposing reasons for the victim to lie.
You're saying he could have cross-examined her if he wanted.
He could and did cross-examine her out candidly rather effectively. I believe it's a bench trial, so unlike many trials we can sort of peer into the mind of the trial of fact and know what they thought of the evidence. The cross-examination here was so devastatingly effective that the trial court either directly says or comes very close to directly saying, I don't find the victim to be a particularly credible witness.
But that kind of has a double-edged sword, because but for the trial court's, I guess, waffling determination in the hearing, if that little piece of information regarding the extramarital affair, gaming, this system to get advantage in the divorce, had those things been able to be properly considered by the trial court, would that not put it over the edge?
Your Honor, I don't know, not in this case, and I think really, and perhaps I was in a very long-winded way ultimately getting here when I was discussing the facts of Olden. We have a bit of a different motivation to lie here than in Olden that I do think is an important distinction. But more directly responsive to Your Honor's question, there are other witnesses here whose testimony would be wholly unaffected by, you know, whatever might have come out about this extramarital affair. The two witnesses, Mr. Nowicki and I can't remember the other, Ms. James is what's springing to mind. But these two other witnesses that the defendant communicates with after this attack and essentially says that he had sex with the victim while she was asleep without her permission. And the trial court specifically finds them to be credible. You know, these are not parties who are in the middle of this really contentious divorce proceedings. They are parties who are, as best can be gleaned from the record, friendly to both the victim and the defendant, who don't have sort of a dog in the fight on either side, but they receive communications from the defendant almost immediately after this attack. You know, I did something stupid. At one point, if my recollection of the record is correct, one of the friends sort of asked the defendant if he had sex with the victim in an unconsensual manner. So we have these witnesses whose credibility doesn't really in any way depend on these allegations of an extramarital affair. So really, I think the calculus would be about the same even if this extramarital affair evidence had come in. The trial court would be sitting there with a defendant whose testimony he didn't really buy, and a victim whose testimony he didn't really buy, and then two witnesses who are disinterested parties who gave strong, credible testimony that would be unaffected by this introduction of new evidence. There was certainly a lot of discussion in this case about the victim's sort of motivations to lie. They are, as best I can tell from the record, largely cabined to wanting to gain an advantage in the divorce proceeding. That they are not, that the motivation to lie doesn't lie as it did in Olden out of some desire to protect this relationship with the person the victim's having an extramarital affair with. That's the motivation to lie in Olden was the affair, and that's not what we have here. The motivation to lie here is the divorce. There was discussion of the divorce. There was effective discussion of the divorce, but what tipped the scales was not the victim, was not the defendant, it was these other third parties, and regardless of what came out about this extramarital affair, these third parties would not be affected. So that's why I think there's not a confrontation problem under plain error, and I would be making the same argument to the court under plenary review that the difference in motivation to lie and really the sort of starring role of these third parties in this case make this qualitatively different from Olden in a way that matters, in a way that prevents there being a confrontation problem.
Thank you, counsel.
Unless this court has further questions, I'd ask that you affirm.
Judge.
Oh, I'm good.
Thank you, Your Honor.
Thank you, counsel. Mr. McNally?
I'd like to clarify a factual aspect or finding by the trial court. And I thought I had it written down somewhere to the specific site, but I don't. The trial court did not necessarily give Mr. Nowicki or Ms. Mitchell, the two people who testified about statements by Mr. Dreaden, did not give them that high a valence of credibility that is presented to the court. In fact, you'll find in there that the trial court said, I see that they are aligned with Ms. Dreaden, or Ms. Parker as she was called during the trial. And made a specific observation that they were with her, sitting with her after they testified, and said that I can see that they're aligned on her side of this matter.
The stronger piece of what the state's argument was that there was text messages
Yes.
in this case where the defendant, and I was unable to see those prior to taking the bench today, but the gist from the brief was that the text messages from the defendant were admissions in and of themselves to the unconsensual nature of the rape of the encounter between him and the victim here. Is that accurate?
It's accurate from the state's perspective in their brief, but from my brief, I also pointed out things that were in the text messages where Mr. Dreaden says, I did not intend to rape her. I did not intend to do this. I wanted to get her back. I wanted her to wake up and fall in my arms, and we have more typical marital sex, I guess. So there's two perspectives on that.
I'm still struggling
Yes,
with the
Judge.
motivation aspect in terms of the affair here. What did the defendant present to the trial court in terms of an explanation of how there was a motivation to lie here? And is there some assertion of preservation of that relationship in this case in terms of the extramarital affair, and how's the motivation linkage arising here?
By the time they were getting to trial, the parties were deep into their divorce, and they were fighting over visitation of the children. So the motivation for the accusation of rape was
Not for the accusation of rape, but how the affair plays into it, and why is the affair? I mean, what does that matter? In Olden, you have issues in terms of why you would not want the person that you were engaged in an affair with to know that you had consensual sexual relations. And here, what's the motivation with regard to not knowing that there was this, let's say your client's right, it was a consensual relationship. What's the motivation for lying about that with regard to the affair?
because the divorce judge, I think it's Judge Scarlett, had made a finding that Miss Dreaden had been untruthful about the affair. Now, it was clear that the affair was one of the issues in the divorce case. And by saying that I was raped, it begins to minimize or take a little bit of the fire or steam out of that particular claim by Mr. Dreaden about her having an affair and leaving the children with him, abandoning the children, so to speak. So it begins to show inequities on both sides, or unclean hands by both sides.
I'm following the motivation or the understanding in terms of not telling the truth about the affair, but in terms of the rape. I mean, this case is about the rape. So what's the motive? How is that affair coming into play here in terms of what's her motivation to lie in relationship to the rape in connection with the affair she was having?
To make a false accusation about the rape would help her would take the steam or the sting out of her affair that she was having, as well as give her a better position in the divorce proceedings, because arguably a judge would not let the children stay with someone who had committed rape of their mother. So there is a motivation to lie about the rape that goes beyond just the criminal case in itself. And Judge Utzman, if I could bear with me one thing. You mentioned something about the rape shield law in Kentucky might change Oldham. And I was going to say, if the court sees this as I see it, that this is not a rape shield law analysis, this is a 608 analysis. And I think that's exactly what the trial court ruled on page 31 of volume 2, which is the pretrial motion, or the pretrial hearing, where the court says, but it would not come in as substantive evidence as an exhibit in the trial because extrinsic evidence is not allowed under 608. The whole purpose of making a contemporaneous objection that states the specific grounds is so the trial court's on notice of what's being alleged. I mean, that's really what the most important thing. And here, this trial court had notice because he started analyzing it under 608.
Denying the motion for new trial, the trial judge references 412, right, in terms of that ruling. Does that matter in terms of your argument with regard to the specific reference to 608 that in the motion for new trial, 412 was referenced?
If I had been the trial counsel, I would have said, Judge, this is really 608, not 412. But for up here, I think the one thing we can all agree upon is, both the state, myself, and the court probably, is that this is a bit confusing. And there's a lot of different angles that the trial court and the lawyers were coming at this from. But I think for appellate review here, the fact that it should be under 608 and that the fundamental constitutional right to cross-examine your accuser has been deprived from Mr. Dreaden.
I'm going to just say one more thing, and then I'll let you close. The fact that it is confusing does not bode in your favor for plenary review. That bodes more so in favor of plain error review from my perspective, because we've got so many different things, moving, and it's unclear. I'm not going to prejudge at this point, but there's so many things. You said it yourself. It's confusing. There were a lot of moving parts to this, which gives me some pause when I say, what is it that I'm supposed to review? I'll let you have the last word.
Well, just two-part. One, I hope the court will see that through the context of everything, the trial court was on notice of what this was about. And then the second thing I was going to say is that it's not just Oldham we relied upon. There's other cases from the 10th Circuit, which is just a great case as well, that says that the proper outcome hangs in the balance and that there should be, that evidence of an alleged rape victim's extramarital affair to establish her motive to fabricate the rape allegation is essential. And then the Sixth Circuit has in there as well some language about the need to reveal possible bias, prejudice, or ulterior motives. So it's not just Olden that we're relying upon. There's a lot of case law out there that speaks to the fundamental right to cross-examine your accuser.
Thank you so much, Mr. McNally.
And thank you for allowing me so much time.
All right, the matter will be taken under advisement. Thank you to both parties for argument and brief. Madam Clerk, you may call the next case.
State of Tennessee versus Stanley Williams.